This is Clarence Earl Gideon, and he's a very poor man. He went to school until he was in 8th grade, and then he ran away from home. He was arrested several times and drifted in and out of prison for committing misdemeanors. On June 3rd, 1961, Gideon broke into the Bay Harbor pool room in Panama City, Florida.
I'm breaking in!
And then he got arrested for committing this misdemeanor.
Gideon's case is taken to Bay Circuit Court, the 14th Judicial Court of Florida. Judge, can I please have a court-appointed attorney?
Mr. Gideon, you will not get a court-appointed attorney. You will not receive one because under Florida law, counsel can only appoint for a poor defendant charged with a capital offense. You, Mr. Gideon, did not commit a capital offense, but a state crime, so we cannot provide you with a court-appointed attorney.
After the judge denied Gideon's request, he then went on to represent himself in his case to the court. Due to his lack of education, Gideon did a very poor job defending himself in front of an educated jury and was found guilty of breaking and entering and petty larceny, which is theft of personal property having a value less than a legally specified amount. Gideon was then once again sent to jail. This is so unfair. I am going to prove that I am innocent.
Gideon sought relief from his conviction by filing a petition of writ of habeas corpus in the Florida Supreme Court. He challenged the conviction and sentence on the ground that the trial judge's refusal to appoint counsel violated Gideon's constitutional right. The Florida Supreme Court denied Gideon's petition.
Dang, Nabbit, if the Florida Supreme Court won't hear my case, then maybe the Supreme Court will hear my case. I'll file a petition to them. They'll hear my case! Yay!
In the Supreme Court, the court ruled a unanimous decision. The court held that the Sixth Amendment's guarantee of counsel is a guaranteed right to a fair trial. This ruling overturned the Betts v. Brady case. Justice Black, who disputed the Betts case, stated that reason and reflection require us to recognize that in our adversary system of criminal justice, any person haled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for them.
No one working in biscuit, bread, or cake bakeries should work more than 60 hours a week. This will become a new labor law called the Bake Shop Act.
Hey Lochner, I'm going to work more than 60 hours this week because I love baking cakes.
That is against the Bake Shop Act, but I'll let you.
Hold up! This is illegal. Lochner, you're going to have to pay money. $50 or you're in the summer for 50 days. Until you pay us, you have to sit in the county jail.
This is ridiculous. This labor law is unconstitutional.
I'm the Supreme Court. It is true that the Bake Shop Act is not within any fair meaning of the term a health law and is not dangerous in any degree to morals or in any real and substantial degree to the health of the employee. This man should be freed.
What?
It violates the 14th Amendment of the Constitution. The amendment's due processes clauses doesn't allow any person to be deprived of life, liberty, or property without due process of law. Employers and their employees should have the freedom to construct a contract that deals with their business because it is the liberty of the individual. The baking industry is not an unhealthy trade, so it doesn't need regulation. With a 5-4 majority decision, justice prevails.
Case closed.
Woo!
The Lochner era was a time in American history whenever the court struck down economic regulations adopted by a state based on the court's own notions to the most appropriate means for the state to implement its considered policies.
This started with Lochner versus New York. The year is 1937 in Washington State during the Lochner era, a time where the Supreme Court tended to stay away from regulating big business. Elsie Parrish and her husband stand in line at the West Coast Hotel waiting for their paychecks.
I'm so happy we get to work at the West Coast Hotel doing the same job. We get to be close to each other all day.
Me too. I can't wait to get our paycheck.
Thank you.
Thank you.
Hey, why did I get paid less than you? We do the exact same job. It's because I'm a woman, isn't it?
You should sue the West Coast Hotel for the difference and for equal pay.
I should. Hello, I would like to sue my employer, the West Coast Hotel, due to the fact that I have not been provided with equal pay to my husband, who does the exact same job as me.
Please further make your case.
In 1932, Washington State passed the law Minimum Wages for Women. This law states that women and children get fair minimum wages. I believe that my wage is unfair and therefore not following the minimum wages for women law.
We believe that the law is unconstitutional because the state of Washington does not have the right to determine what the minimum wages we have to set are. That is a violation of the 14th Amendment, and we have the right to freely negotiate contracts and minimum wages with our employees.
We rule in favor with the hotel.
No! I'm taking this. I'm appealing to the Washington State Supreme Court.
We reverse the lower court's ruling and rule in favor of Parrish.
No! Now we're appealing to the Supreme Court.
We stand with the Washington Supreme Court and rule 5-4 in favor of Parrish. The hotel must pay damages to her. In addition, we declare that it is constitutional for the court to set minimum wages. It shall be unlawful to employ women workers in any industry within the state of Washington at wages which are not adequate for their maintenance. This does not violate the 14th Amendment because it is being done to protect the welfare and health of all citizens.
Yay!
This groundbreaking court ruling ended the Lochner era. Courts now decided to make more decisions on business. I want candy! Hi. Hi. Bye. Ah!